For delivery of judgment, jail appeal 39 of 2025.
Appeal is dismissed, sentence to run concurrently.
I seek your lordship's indulgence in mentioning item number 6, your lordship, the hearing list.
60.
6,
6.
yes.
There's no hearing list, even division bench.
Yes, division
Today's
bench
list.
hearing list, yes.
I
Today's
can-
list.
okay.
Today list.
Yes.
Your lordship, if this matter may be listed on 9th September.
9 September.
Yes, I have taken the consent of the
Yes.
other party.
My lords, I've always prayed that this matter may be heard at the earliest. But my lords, let this be the last time. Your lordships would see the last order also in 15 July. My lords, this honorable court had also, my lords, made a caveat therein that subject to no more adjournments. Or else the petition would become infructuous. Challenge to the rules.
All right, then have it, when do you want it? 9th?
Yes, your lordship.
Is the AG appearing here?
Yes, my lords.
Yes, your lordship.
Mr. Deb, you are appearing in this matter?
Is challenge to a particular rule?
Yes?
Yes, my lord, I am appearing in this matter.
All right, so we are fixing it on 9th of September.
9 September, my lord.
At least let the petitioners argue the matter. You can give your
Okay.
reply. 9th,
I'm so grateful.
9 September, on the request of the Government Council.
For admission, item number 1.
May I plead your lordship?
Yes?
Lordship, I beg to mention item number 4.
Uh,
Lordship, an objection was filed by the other side in the IA. Lordship, we need 3 weeks time to file the reply.
What reply to an objection? This is a
Yes,
IA
sir.
for what?
Delay of condonation.
Then what is the question of filing a reply? No reply.
Your Worship, in fact, I was the one who filed the reply to the application for condonation of delay. It was filed yesterday. It's not come on record. But Your Worship, I mean, yeah, what is the requirement of filing a reply?
All right, but even otherwise you say it is not on record. So
But not,
let it come in the first week of September. Item 4 on the submissions made by the council appearing for the applicant. Matter stands deferred to be listed on 2nd of September. And the objections filed by the opposite party be connected to the case records by the registry by the next date.
Amo.
Placed accordingly. Yes.
Much obliged.
Item number 1.
Lordship,
My lord,
the
in-
leading
my lord, in this
counsel.
matter, on the previous occasion,
Yes.
that is on 13th of August, my lord,
Yes.
if I can take your lordship to the order passed by this honorable bench.
Yes.
On 13th, and prior to that on 29th of July. If my lord first, if your lordship can see the order of 29th July, it's a very short order,
29 July.
July. My lord has got it?
Yes, 3 lines.
On the prayer of Mr. K. Jain, learned counsel for the petitioner lists the matter on 13th August 2026 for admission hearing, wherein the issue of maintainability of the PIL will also be considered. So, my lord, on 13th of August, the matter was taken up by this honorable court, and the matter was heard at length on merits. And thereafter, my lord, An order was passed, a detailed order was passed in this matter. Lordship will kindly come to the order dated 13th
Yes,
August 2026.
yes,
Heard Mr. So-and-so, learned counsel for the petitioner, and also heard Advocate General for the state assisted by so-and-so. The grievance of the petitioner is reflected in the order dated 20th May 2026, and therefore the same is not reiterated herein. The learned counsel for the petitioner in course of his submission has stressed only one point. My lord will kindly note, only one point, that in event there is more than one lowest bidder, there is no fixed criteria on the basis of which the successful bidder will be selected. So this is the only grievance which had been agitated by the learned counsel for the petitioner on the last occasion after his detailed submission. It is in the said context that the Advocate General, while maintaining his stand that the PIL is not maintainable, that is my stand from the very beginning, my lord, has submitted that in view of the order of stay operating by the order dated 20th May 2026, the Government of Mizoram Finance Department Expenditure Control Branch had issued an office memorandum dated 26th May 2026, which is appended to the affidavit in opposition of the state respondents 1 to 3. It is submitted that for the time being, the provisions of clause 4 of the CPWD manual would be followed until further instructions are issued. It is submitted that the competent authorities in the appropriate government would further clarify the criteria for selection of the bidders in the event there are more than one successful lowest bidder, so as to bring transparency in the selection process and also to notify the authorities who would be competent authority to have financial delegation based on the value of the contract for the engineering departments of the state, which executes work on the basis of the tenders. In view of the said submissions of the learned AG, the court is of considered view that keeping the issue of maintainability of the PIL open, if the state government comes up with a selection criteria as indicated above, the grievance of the petitioner would be fully addressed and nothing more would remain in the PIL. Accordingly, in view of the submissions made by the AG, insofar as the interim order dated 20th May 2026 is concerned, the same is modified so as to enable the state to proceed with the tender process. However, for the time being, the state's engineering department shall follow the OM dated 26th May 2026 till the policy of selection of the lowest bidder in the event that there is more than one lowest bidder, as suggested by the AG, is notified. Accordingly, liberty is granted to the state to bring further instructions, if any, and on the selection criteria along with the identification of the competent authority in the event there are more than one lowest bidder. In the event any further notification or office memorandum are issued, liberty is granted to the state to make a mention out of understanding. The order modifying the interim order dated 20 May 2026 shall be revisited on the next date of listing. As agreed to by both the sides, list the matter again on 25th August 2026. So in view of the order and in compliance with the order passed by this honorable court, my lord, as per paragraph 5, as per paragraph 5, that in view of the said submissions of the AG, the court is of the considered view that keeping the issue of maintainability of the PIL open, if the state government comes up with a selection criteria as indicated above, the grievance of the petitioner would be fully addressed and nothing more would remain in the PIL. So, my lord, in compliance with the said order, the notification has been issued and Lordship will kindly see that an additional affidavit has been filed along with the said notification. My lord will kindly come to the additional affidavit which has been filed along with the notification dated 19th August 2026 in compliance with the order passed by this honorable court. My lord, this is a tender matter. PIL has been filed in a tender matter.
No, where is the notification? The
My lord
first
will come to the additional affidavit which has been filed.
What does it provide for?
Lordship will kindly come to the page, Lordship, page 4 of the affidavit. The rules which will govern the selection criteria while selection of bidder or contractors in case of a tight bid. Lordship will kindly allow me to read it.
Yes.
Procedure for selection, my lord has got the relevant portion.
Yes.
Procedure for selection amongst multiple responsible lowest bidder L1 and determination of competent authority and procurement works regarding. Attention is hereby invited to the Government of Mizoram notification number so and so relating inter alia to fixation of the permissible lower limit and upper ceiling of the estimated cost put to the tender. Part 4 of the general rules and directions of the standard bidding documents for procurement of building and other related works, wide annexure 1 of office memorandum number so and so, dated so and so, states that in case the lowest tendered amount worked out on the basis of the quoted rate of individual items of 2 or more bidders is saved, then the successful bidder among such bidders shall be decided by the competent authority. The Honorable Gauhati High Court Aizawl Bench in PIL number 1 of 2026, so and so versus State of Mizoram, by interim order dated 20th May 2026, stayed inter alia the operation of the above provisions. In pursuance to the aforesaid interim order, the Finance Department issued office memorandum dated so and so, whereby the aforesaid notification and the relevant provision of the standard bidding documents were kept inoperative with effect from 20th May 2026 and until further orders. And it was provided that procurement works would in the meantime be governed by the Mizoram Transparency in Public Procurement Act 2008 and the Mizoram Public Procurement Rules 2020 and the applicable provisions of Clause 4 of the CPWD Manual. Subsequently, the Honorable Gauhati High Court Aizawl Bench, by order dated 13th August 2026, the order which I was referring to just now, passed in the aforesaid PIL, has insofar as the interim order dated 20th May 2026 is concerned, modified the stated order. It has permitted the state to proceed with the tender process and has granted liberty to the state to formulate an appropriate criterion for selection amongst multiple L1 bidders and to specify the competent authority in relation to the contract value. It is therefore necessary to prescribe guidelines for selection of bidder contractor in case of tight bids to deal with cases where 2 or more responsive bidders are placed at L1 after evaluation of their bids and application of all applicable procurement preferences. Accordingly, the following procedures for selection amongst multiple lowest bidders L1 and determination of the competent authority is hereby prescribed to be followed by all concerned with immediate effect and until further orders. Guidelines for selection of multiple bidder contractor in case of tight bids. In case of tight bids, the following criteria will govern the selection of the successful bidder. Number 1, record of past performance in contract works. Number 2, record of experience in similar works. Number 3, litigation, current or during the past 5 years in which the bidder is involved. Number 4, record of poor performance such as abandoning the works, not properly completing the contract, inordinate delay in completion. Number 5, record of financial failure. Number 6, availability of essential construction equipments and manpower. Number 7, bid capacity. Notwithstanding the above, contractors whose relatives are working as divisional accountant or engineering officers between the grades of superintendent engineers and junior engineer, both inclusive, in the circle responsible for award and execution of work and execution of contract will be summarily rejected. For this purpose, a near relative shall mean wife, husband, parents, grandparents, children, granddaughter, brothers, sisters, uncles, aunts, first cousin and their corresponding in-laws. My lord, this is to ensure total transparency in the selection process. Now the competent authority for the purpose of these guidelines will be a committee under the chairmanship of the next higher authority to the authority competent to accept the bid tender as per delegation of the financial powers in standard operating procedures for CPWD works manual in force as given in the table below. Engineer-in-chief, chairman will be secretary PWD, member secretary engineer-in-chief, members all chief engineers, jurisdiction all Mizoram. Number 2, chief engineer, chairman engineer-in-chief, member secretary concerned chief engineer, members all chief engineers, jurisdiction concerned zone, superintendent engineer, chairman chief engineer concerned, member secretary concerned, superintendent engineer, members all superintending engineers under the chief engineer zone, jurisdiction concerned circle. Next is executive engineer, superintending engineer concerned executive engineer, all executive engineer under the circle concerned division. So my lord, the grievance of the petitioner in connection to the tied bids and who will be the competent authority for selection, that is number 1, and how the process will be completed. The entire matter is elaborately specified in this particular guideline, my lord, and in order to ensure transparency, everything has been stated in detail. As per the order dated 13th of August 2026, my lord, and in compliance with the order, paragraph 5 of the order, the government has issued this notification.
All right.
Now, my lord, with regard to the maintainability,
If I may kindly interfere, Lordship, the leading counsel, Mr. Kartik Jain, is indisposed. He has already submitted to move the adjournment on 18th of August, which we have already taken consent from the other party to be listed on 31st of August, Lordship. So, without wasting any more time, if this can be adjourned today,
my
Lordship.
lord, this is not a waste of time. It's a concern where the state government is unable to proceed with the development works. This has been deliberately dragged at the instance of the petitioner, and I really wonder whether it is a
Mr.
public
Advocate
interest.
General, have you been informed that the other side counsel is indisposed?
Yes,
and
Lordship, we have given
you
the
would not be in a position to
application
appear?
also.
Have you been informed about that? That is their submission.
My lord, that is their submission which I have come to know now.
Okay.
But my lord, this is an extremely urgent matter, at least since the notification has been issued.
No, that's right.
As
So
per-
we, in view of this notification being
At least the interim order may be
Issue.
modified. At least the interim order may be modified, my lord. That is my humble
it
submission.
appears that your grievances have been redressed.
Yes, Lordship.
So it's on this point you come back and address the court on 31st.
Yes,
We'll
Lordship.
fix it on 31st for final orders. Mr. Dame?
Well, my lord, in the meantime, at least all the development works has been stopped, my lord. At least let the interim order be vacated so that we can proceed, my lord. And let the matter be disposed of. This will be disposed of, my lord, on 31st. I agree to it.
In
My
the
humble
absence
and
of the
respectful
council, we
sub-
would not like to pass an order. When the council is not present, then would not be proper, particularly if it is registered as a public interest litigation.
My lord, public interest litigation is absolutely, once a notice is issued, it's absolutely within the domain of the
No,
court, my lord.
that's okay, Mr. Deb, we
neither
understand
the petitioner nor
understand
the-
your anxiety, but It's a matter of few days. Wait for Monday.
Lordship, this matter, my lord,
We'll
up to you.
record
Up to your lordship, my lord, but this matter
we'll record the
is being
submission of the
continued
council.
since early this year. And since May, my lord, May last week, my lord, that is on 20th of May, my lord, since the interim order has been passed, we are unable to proceed with any work whatsoever.
Have you filed any IA?
My lords,
Any IA has been filed for vacating?
lordship, not IA, but on the basis of the on the basis of the order which has been passed on 13th of August, this affidavit has been filed along with the guidelines.
There is an IA.
There is a total complaints, my lord.
No, Mr. Deb, there is an IA.
There is an IA earlier.
Yes, there is an IA.
Earlier it has been filed. Not now. At least, my lord, let the interim order be vacated. What remains in the PIL?
Therefore, we find that your submission is that once the notification is issued, nothing remains in the PIL, and this is what exactly was noted by the court, by predecessor bench.
Exactly,
So
my lord,
therefore,
exactly.
we'll fix the matter on 31st, and we'll also indicate in the event matter is not heard finally, the liberty will be given to the state to press the IA. The IA is pending here. Right?
Lordship, I agree to that, but my lord will also appreciate that a small state like Mizoram, we are unable to proceed with any development works, and there are certain centrally sponsored schemes.
You should at least give them 24 hours, 48 hours to rebut, to get their instructions on this notification. This affidavit appears to have been filed yesterday.
My lord,
The matter was directed to be listed by the last order, which was in, I think, in June. Was it in June? So, I think
no, my lord, in August.
August, all right. It was directed.
My lord can fix the matter on Friday. Lordship will kindly fix the matter on Friday.
Friday, I'm told, is a holiday here. So therefore, the earliest day available on 31st, Monday.
As your lordship desires.
Huh? Heard counsel for the parties, Mr. Biswajit Deb, Advocate General.
My lord will
Yes,
kindly
yes.
make a note of my submissions.
Yes, I'll do that.
That I have pressed for the vacating of the order, and that nothing remains after this guideline has been issued.
Right.
In compliance with the order.
You permit us to dictate the order. If there's any deficiency, you can remind us.
My lord, my lord, my lord.
By the earlier order dated 13th of August 2026, coordinate bench, while hearing the matter, has director has, upon hearing the parties before the court, recorded a finding that the only ground on urged by the counsel for the PIL, petitioner for the PIL, counsel for the PIL petitioner, that in the event there is more than one lowest bidder, there is no fixed criteria on the basis of which the successful bidder would be selected. Stop. The state, on the other hand, led by the Advocate General, learned Advocate General, had submitted before the court that the PIL is not maintainable, and considering the
Not maintainable of
submissions
the, as per the guidelines of the Honorable Supreme Court. That is what I had placed earlier also, my lord.
The-
The guidelines, compilation of guidelines to be
The
followed
Advocate
for
General-
entertaining.
The Advocate General will also, had also urged before the court judgments of the apex court to submit that the PIL is not maintainable.
My lord, guidelines being issued by the Supreme Court.
Where are the guidelines? Where do you
Lordship,
submit the guidelines?
my learned additional AG will hand over the guidelines, my lord.
No, we are recording your submissions as was recorded in the last order of 13.8. Did you press the guidelines there?
Yes, my lord.
It's not
And I have
recorded.
placed the guidelines also.
Is it? It's not recorded
I
in
was,
the
I
order.
was physically present, Lordship, I was physically present, and I placed the guidelines also.
Doesn't seem to have been recorded in the order.
Maybe, my lord, because the order was passed later on, it was not dictated in the open
No,
court.
we don't know. We are
So I could
just reproducing the order which was passed
Lordship,
on
Lordship,
13.8.26.
Lordship,
The court was of the view that keeping the question of maintainability open, if the state government comes up with a selection criteria in the event of a tie, TI tie between the lowest bidders, then the grievance of the PIL petitioner would be fully redressed and nothing more would remain in the PIL stock. On that understanding, the matter was fixed on 25/8/2026, permitting the state to furnish before the court such selection criteria, and the interim order which was passed on 2005/26 was modified to enable the state to proceed with the tender process for the time being, to follow the state's engineering department's OM dated 26/5/2026 till the policy of selection of the lowest bidder is notified by the state. Stop. The matter was fixed today. The state has filed an additional affidavit dated 24 August 2026, enclosing a notification dated 19th August 2026. By the said notification, the following guidelines for bidders or contractors in case of tied bids, TID tied bids. was
multiple
notified.
tight bids, my lord.
Sorry?
Multiple tight bids, my lord. In case there is more than one tight bid,
Selection of bidders or contractors in cases of tied bids to deal with cases where there are two or more responsive bidders which are placed at L1 after evaluation of their bids and the application of all the applicable procurement preferences. Stop. The guidelines notified by the said notification are extracted as under. Stop. Para. The learned Advocate General has strenuously urged that in view of these guidelines being notified, nothing further remains to be decided in the PIL, and therefore the PIL should be closed and the interim orders should be vacated, permitting the state to proceed with the development works which are notified by way of public procurement or other tender bids. Stop. Learned Counsel, appearing for the PIL petitioner, on the other end submits. Counsel
Kartik Jain.
Mr. K. Jain, appearing for the PIL petitioner, is indisposed, and consent was also obtained from the opposite party that the matter should be fixed on 31st of August. Stop. Mr. Deb, on the other end, strenuously urged before the court that in view of these guidelines being furnished published by the state government, notifying the procedure, at least the interim order should be vacated, enabling the state to proceed with the tender works. Stop. Considering the submissions made and taking into account the fact that this is a public interest litigation, this court considers it appropriate to have the matter listed on 31st of August for further orders. Stop. It is ordered that in deference to the earlier order dated 13th of August 2026, the state has notified the procedure to be followed by the state in cases of selection of bidders or contractors, in cases of tied bids, to deal in cases where two or more responsive bidders are placed at L1 after evaluation, comma, and the same being brought on record by way of an additional affidavit with advance copies being served on the counsel for the petitioner. Stop. Comma. The matter should be attempted to be disposed of on the next date of listing, particularly taking note of the observation of the coordinate bench by in its order dated 13/8/2026 that the PIL petitioner has stressed only one point, that in the event there is more than one lowest bidder, there is no fixed criteria on the basis of which the successful bidder would be selected. Stop. In that view of the matter, it appears to the court that after the publication of the notification, which is brought on record, notification dated 19th of August 2026, brought on record by way of the additional affidavit, the grievance of the PIL petitioner appears to have been redressed. Stop. In that view of the matter, attempt will be made to pass final orders in the PIL on the next date of listing. Stop. It is made clear that in the event the PIL is not disposed of for one reason or the other, it will be open for the state to press their IA, being IA number so-and-so, IA number 151 in PIL 1 of 2026, filed for vacating of the interim orders, vacating or modification of the interim orders. Accordingly, release this matter on 31st.
Obliged.
I am deeply obliged, ma'am.
Item number 2.
My Lords, as per the last court's order, we have taken steps for service upon the respondents number 13 to 16, my Lords. And I
Entry card
believe-
is awaited.
Yes, and I believe my learned friends that are appearing for the respondent number 13 to 16, my Lord.
Your Worship, I have instructions to appear on behalf of respondent 14.
14.
Yes, I'll be filing my power today, Your Worship.
I'm for responding 15, my lord.
15. And 13 and 14? 13 and 16? Anybody? No,
Your Lordship, I'm appearing for respondent number 16.
16.
So we'll be filing our vakalat number today.
Okay. Only 13 is left.
13 is left, my Lord.
All right. In deference to the order dated 27/7/2026, whereby notice was issued, steps were undertaken on respondents 13 to 16. Stop. Office note dated 21/8/2026 reflects that service report on respondent 13 to 16 is awaited. Where Mr. Who's appearing for 14?
I'm appearing.
Mr. Malhotra appears for respondent 14. Mr.
Pilal Romega.
Manga appears for respondent 15.
15.
And Mr.
KVL Remrodeka.
Mr. So-and-so appears for respondent 16. The learned counsel for the parties are permitted to file their power and complete their instructions. Stop. Matters be listed after 2 weeks,
At least 2 weeks, my lord.
3 weeks, enabling the respondents to complete their instructions and file affidavit, if so advised. Registry will also make necessary endorsements with the status of service on respondent number 13 by the next date of listing. Relist accordingly. Mr. So you're appearing for state?
Yes, my Lord. 7 to
12. Learned counsel appears for 7 to 12.
Obliged, my Lord.
Item number 3.
Yesterday, we have filed affidavit on behalf of the state level monitoring committee. It may not be on record yet, my lord.
24th.
Yes.
Yes, it is on record.
Yeah, it is on. My lord, we have filed this affidavit, and we have mentioned we have expressed our difficulties in convening a committee at para 3, page 78.
As per the Supreme Court direction, it was to be filed by 25th.
Yes.
Twenty-first. You're supposed to file it before 21st.
21st.
Anyways. So what do you say here?
My lord, at page 78, para 3, we have stated that since the chairperson of the committee is the Honorable Judge of the Gauhati High Court, Justice Nelson, we could not convene a meeting because of his absence. My lord, he will be coming in the next week. Hopefully, there will be some developments.
All right, have you received a copy, Mr. Malhotra?
Yes, Your Worship, I've received.
All right, please go through it and apprise the court
They will come next week then, Your Worship.
next week.
Yes.
Next week on 31st itself, or we'll have it a little later?
Wednesday, appeal.
Second?
Second.
All right. The Mr. A.R. Malhotra appears for the, you're the amicus here,
Yes, Your Worship. I'm the standing counsel for the resort bench here.
standing counsel for Guwahati High Court Aizawl Bench, and MS Linda, learned additional AG, appearing for the state, as permitted by the earlier order, as directed by the last order, dated so-and-so. State has filed the affidavit on 24th of August 2026. So copies have been served on the standing counsel for the Guwahati High Court Aizawl Bench. So in para 3, it is stated that since the chairperson of the State Level Monitoring Committee on OCI is a sitting Honorable Judge of the Guwahati High Court, in his absence, due to his inavailability in Aizawl, meeting could not be held, and therefore they pray for some further time to convene the meeting under his chairmanship, and thereafter apprise the court. So, as agreed to by the council for the parties, released again on 2nd of September.
Obliged.
Item number 5.
Yes.
Good morning, Lordships. Lordships, I'm praying for condonation of only 4 days delay.
In filing the writ appeal,
Yes, Lordship.
who's for the other side? What are your grounds for delay?
Really, it is only because of technical error at the time of filing.
Legal error.
Yes, yes.
Any objections?
My lord, with regards to IA itself, there is nothing to be objected. However, in the writ appeal, my lord, there is nothing wrong in the judgment and order passed by the Lana
No, we are not hearing the writ appeal. It's only on the delay point. Unless the delay is condoned, we can't pass orders on the appeal. What is the appeal about?
It is about land negotiation, my lord.
Compensation.
Yes,
delay.
Compensation.
yes.
Yeah, okay.
The Honorable Supreme Court gave us liberty on the 17th of 2025. Having said that, the single judge ruled or did appeal that the case is res judicata.
Okay, delay. Cepat. Ni bang. Ni ang kan.
Oh, that is about that. Thank you, madam.
Yes, respondents, anything? Submit.
My lord, 3 days delay only. Then let the delay may be condoned. However, the matter may be disposed of. The writ appeal may be disposed of today because there is no any ground. There is no requirement for issuance of notice, my lord.
Is the appeal also listed?
Number?
Not numbered? Only then it will be numbered. Heard counsel for the parties, this is an application seeking a delay, condonation of a delay of 4 days, which had occurred in preparing an appeal, writ appeal against the judgment and order dated 14/7/2026, passed in WPC 83 of 2026. The writ petitioners claim to be residents of the border areas and were not conversant with the legal requirements, as also the limitation period prescribed for preparing an appeal. How many appellants are there?
Altogether 39.
39.
Yes.
There are 39 appellants in the accompanying appeal. You say your first paragraph says 38 families. Is it 38 or 39?
30 in the sense, I'm not counting the attorney.
Attorney.
With the attorney,
38 families. Stop. The appeal is being filed through. It's filed through an attorney
yes, Lordship.
by executing a power of attorney.
And Lordship,
Yes.
Lordship may be kind enough to have the writ appeal placed tomorrow if possible.
Tomorrow is not possible. It's a holiday. The learned counsel submits that this error, this delay had occurred because of certain technical defects which were noticed at the time of filing the appeal, which required correction, and as a consequence thereof, the delay of unintended delay of 4 days had occurred. Stop. The learned counsel submits that this delay was not intentional or deliberate, as the appellants are claiming the compensation for the land stated to have been acquired by the respondents. And therefore, it does not serve them any purpose to unduly delay the filing of the appeal in respect of the judgment and order dated so and so. Stop. Counsel for the learned CGC appearing for the respondent submits that that there is no objection to the if the court considers it appropriate to condone the delay. Stop. Considering the above and considering the principle laid down by the courts that condonation, prayer for condonation should be given, should be liberally construed unless there is lack of bona fides, faltitude, or suppression of any material facts. Stop. Neither of these conditions, none of these conditions are pressed against the petitioners by the respondents, nor is against the respondents. No. Under such circumstances, this court considers it appropriate to condone the delay of 4 days in filing the accompanying appeal. IA stands allowed. The registry will now register the appeal and list it before the court. IA accordingly disposed of.
Thank you, my lord. Thank you.
Yes.
Main case, my lord.
Hmm?
The main case, writ appeal.
Main case will come as and when it is numbered. It has to be numbered. Only after condonation of the delay, the appeal will be numbered. That is what we said. It will be numbered and placed before the bench, available bench. Next week. Appeal will be listed next week.
Lordship, next week, the justice who dismissed the case in the writ is going to sit. So if possible, in your presence, if not tomorrow, day after.
Is it possible? Day after? We'll see that. Let it be decided by the registry. We'll have a word.
Yes, Lordship. Thank you, Lordship.
to be listed after
2 weeks, my lord.
2 weeks. Relist this matter again in the hearing list after 2 weeks.
Highly obliged.
May it please your lordship seek indulgence on mentioning part 2 item number 18.
18.
With due respect, your lordship, if the matter be taken after 3 weeks.
This is also fixed today.
Yes, your lordship, the leading counsel for the respondent number 1 has absent due to her health issue. So, in fact, yesterday she submitted a leave application to the register. So, if the matter be taken after 3 weeks.
Item 18 on the request made on behalf of the respondent number 2.
1.
1. On the ground that the learned counsel is indisposed, stands deferred to be listed after 2 weeks.
My lord, I'm appearing on behalf of the appellants. If the matter can be fixed on 16th of September.
16 September. As agreed to by both counsel, both parties, matter will be listed on 16th of September.
Supplies.
Lordship, if I make a mention of item 29 of part 2.
29.
For respondent number 4, and if this matter may kindly be taken up after 4 weeks.
29. You're appearing for the
Respondent
appellant.
number 4.
Respondent 4.
Yes, ma'am.
Who's for the appellant? Have you informed?
Consent to be taken.
29 on the request of the counsel for the respondent number 4. Matter stands deferred to be listed after 3 weeks.
4 weeks.
4 weeks. All right.
Obliged.
Yes.
Daily list for motion, item number 1.
My lord, I was supposed to obtain instruction in the last court order. If I may permit it to produce. Number 45.
May it please your lordship, I am appearing on behalf of the state respondents 1 to 3. I was also instructed to obtain instructions. However, your lordship, I have not yet received any instructions from the concerned department.
My lord, the MHA, Union of India, and NPCC has signed MOU with regards to border fencing. Then let the opportunity of being heard be given to the NPCC. Let formal notice may be issued first.
NPCC. Is NPCC a party here?
Respondent 5 here.
Respondent number 5.
Okay.
They have no standing counsel.
In deference to the earlier order, the learned CGC has appeared before the court with the instructions that the award amount of rupees 6,04,39,330 was paid to the concerned beneficiaries through the demand draft number 052850 dated 15/4/2009 issued by the State Bank of India. However, solatium and interests as claimed in the present petition were not paid. Stop. It is further submitted that at this stage, notice be issued to the respondents to complete their instructions in the matter. Where having heard the counsel for parties, let notice issue returnable 3 weeks. The learned CGC enters appearances on behalf of
Respondent number 4.
respondent number 4. State counsel appears on behalf of 1, 2, and 3.
Yes, your lordship.
Therefore, no formal notice need be issued to respondents 1, 2, 3, 4 as they are represented by their respective counsel. However, extra copies be furnished to the respective council within 1 week from today. Steps on respondent 5 by speed post within 1 week from today. Release this matter immediately after the returnable date. Mr. Malhotra appears for the petitioners.
Item number 2.
May it please your lordship, I am appearing on behalf of respondent number 6. 6 is Kala Longklai district. Your lordship, the advanced copies of the affidavit of opposition has been provided to the concerned councils, and if I may be granted 1 week's time to file my affidavit, your lordship, on behalf of Kala Longklai, respondent number 6.
Respondent 6, you want to file your affidavit?
Yes, your lordship. I'll be able to file it by the second week of September, your lordship.
And there's an additional affidavit filed by respondent 2, 7 and 8.
Lodge. We have raised the question of maintainability of the alleged petition.
Okay. Have you received the copy of the affidavit?
We have not received it.
Not received.
Okay.
It was filed on 6th of August.
If that might have been additional affidavit.
Not received.
All right. Heard Mr. Joseph, counsel for the petitioner. And learned government advocate appearing on behalf of respondent number 326. Who submits? You have filed your affidavit? No.
On behalf of the state respondents, we have already filed our affidavit.
Okay. Who have already filed their affidavit. So far as the respondent number who represents the Kala?
Yes, your lordship, I represent the Kala, respondent number 6, your lordship, Kala Longklai district.
Respondent number 6. Learned counsel representing the deputy commissioner, Longklai district, Mizoram, which is also the Kala CALA Kala. They would like to file their affidavit within 2 weeks.
Yes, your lordship.
My lord, I think
The private respondents have also filed their additional affidavit, copies of which be served on the respective counsel for the petition.
my lord, I believe similar matters are coming up on 21st or 22nd of September.
21st.
21st. So my lord, let this matter also come up on 21st.
Right. It is submitted that similar matters are fixed on 21st of September. Accordingly, let this matter also be listed on 21st of September.
Obliged, my lord.
Item number 3.
Your Lordship, in this matter, pleadings are complete. It may be taken up again on 12th of October for admission hearing, my lord.
12th of
Yes,
September.
because the petitioners are intending to engage another senior counsel.
You want it on 12th of
12th of October, my lord.
October.
12:10, yes, if possible, kindly. I've taken the consent of the other sides, my lord.
Yes.
Okay.
It is submitted that the pleadings are complete in the matter. It is therefore submitted that the matters be listed on 12th October for admission hearing. Relist again on 12th of October.
Much obliged.
Item 4.
My lords, here we're seeking 2 weeks' time, my lords. Some instructions I've received from my client, my lords, I need to verify. So, my lords, if it may be adjourned by 2 weeks. I've informed the other side.
2 weeks.
Yes.
Any objections for the respondents?
No, your lordship, not from the state respondents.
Counsel for the petitioner prays for and is granted 2 weeks' time to complete his instructions in the matter. The state is represented by the government advocate, learned CGC appears for the union, and additional AG, standing counsel for
7 to 9.
appears for 7 to 9, and HIDCL. Yes. You are appearing for?
Respondent number 3,
Mr.
Ram Murmu.
Ram Murmu appears for respondent number 3. Yes.
Obliged.
Item number 5.
Your Lordship, I'm appearing on behalf of my senior, Miss Valentina. My Lord, the leading counsel, Miss Valentina, is currently out of station. I respectfully seek 1 week's time for filing a rejoinder affidavit.
Yes. Respondents, any objection?
No, Your Lordship. No objection.
Prayer is made. Yes.
I'm appearing for the NHIDC. Do you have an objection?
A prayer is made on behalf of the counsel for the petitioner that the rejoinder affidavit is required to be filed. The affidavits filed by the respondents. They pray for a week's time. Prayer made is not objected to by the respondents. Stop MS Government Advocate appears for the state. Letter CGC for the union. Mr. P.J. Saikia, Senior Counsel for NHI DCL.
Lordship.
Release this matter again after 2 weeks. By which time the petitioners will file their rejoinder affidavit.
I'm there for a date, my Lord. 22nd of September.
22nd of September.
Much obliged, Your Lordship.
Item number 9. Item number 6.
May I please, Your Lordship?
Yes.
I'm the humble counsel of this court. However, I'm appearing in person in this matter. It is the case of mine, my Lord. As per direction issued by the Honorable Division Bench, my Lord, in paragraph 65 and 66, that the connected matter, writ criminal, can be dismissed with the liberty to approach the appropriate forum, Your Lordship.
I think on the last occasion there was a submission made by the counsel for the respondents that the
writ petition was
writ petition was dismissed by the appellate court. That perhaps is not correctly reflected in the appellate court's order. Appellate court has rather stated that a formal order of dismissal is required to be passed by the
That Lordship has already been passed, Lordship, on 4/6/2026, Lordship, in the writ petition, in the writ petition criminal 9 of 2025, Lordship.
That's right. That on the day when this order was passed, that order was not uploaded, so it was not reflected. Therefore, we thought we need to get the facts straight. Subsequently, it was pointed out that an order has already been passed in this WPC, right?
Lordship.
So, otherwise, we were to dispose of this matter and remand the matters back to the
yes, Lordship.
the trial court for deciding the matter afresh. What was the order challenged here?
Lordship, that was the last page of the civil writ petition, my Lord. It was in page 144, my Lord.
Order dated 28/1/26?
Correct, my Lord.
Yes.
Our main grievances is that
this order was passed on the ground that the matter will be carried on after the disposal of the writ petition criminal.
Correct, my lord.
And you are
They-
you are agreed by this order. So
We are
now-
agreed by the order because that order did not reflect the main issue, the undisputed amount, my lord. If
so-
my lord comes to
No,
page 16.
now therefore, as per the last date of hearing, since the writ appeal was dismissed and
Lordship, the writ appeal was allowed, Lordship.
writ appeal was allowed with a view that there is no merit in the writ petition criminal, and also subsequent thereto, an order was passed by a coordinate bench dismissing that order, that writ petition. So therefore, the matter can go back to the trial court. You can re-agitate the matter.
Yes, I follow that, your lordship.
Yes.
My respectful submission is that there was no objections from the respondents in regard to undisputed amount. That has been expressed in page 60 and page 112, your lordship. If my lord comes to page 60, in para 22.
No, is that position not admitted by the court below? Is that position rejected by the, is that contention rejected by the court?
The lower court was silent, my lord. The lower court was silent, my lord.
That's
in
right.
In spite of the fact that
that's right. Therefore, we will remand the matter back, requesting the court below to decide all the matters afresh.
Lordship, within a fixed time frame, Lordship, because there is an injunction.
Yes, within a fixed time frame, yes.
Lordship.
Lordship,
yes.
With most respect, my lord, there was no issue in regard of the undisputed amount that is in the record, my lord. If they have any objection in regard to the undisputed amount, let them speak up, let it brought on record. And someone has to be responsible, my lord. Without any fault of mine, I'm suffering, my lord. There are disputed amount and undisputed amount. My whole account was freeze, my lord.
What are you challenging before the court? What are you challenging before the civil judge senior division?
The illegal freezing of my account, my lord.
That's right. So therefore, this matter will have to be heard by the court. This court has not heard this matter in view of the pendency of writ petition criminal 9 of 2025.
My lord, that may not be correct, Lordship. There was a full and fledged hearing, Lordship, and the matter was CAV. The court below has not passed the order. We have filed an application under Order 39 Rule 2 for vacating the interim order, Lordship. And then there was a full-fledged hearing for 2 days, Lordship. After that, it was heard on the month of August 2025. From August 2025 till December 2025, the court has not passed any order, Lordship, and that is very detrimental to me. And then, Lordship, because of this litigation, again 1 year has passed now.
No, but you are not before the court assailing that.
I'm not before this court, Lordship, but I'm pointing it out.
As on date, are you disputing the fact that as on date, that there is no order, there is some order passed by the court on the application filed by the petitioner?
I'm not disputing that, Lordship.
That court will have to pass an order on the application file.
Yes, Lordship, within a fixed time frame, Lordship.
That is what we intend to do. Right, Mr. Petitioner in person?
I have already pleaded, my lord. If I was sent back regarding to the undisputed amount in the same square, my lord, then it is, my lord, too harsh for me. Nobody had objected for release of the undisputed amount, my lord.
Where is that order? Where is the order rejecting your prayer for release of undisputed amount?
It was not particularly rejected, but it amounts to rejection since it was silent, my lord. Nothing was passed in the order dated 28/1/26, my lord.
28/1/26 only says that this matter, the decision, the court will wait for the decision of the court, this High Court in WPC Criminal 9 of 25. Doesn't say anything more, anything less.
Yes, Criminal 9 of 2025, it has no concern with the undisputed amount, my lord. It is not in touch with the undisputed amount, man.
That would be relevant only when the order is passed. So therefore, we want the matter to be remanded back for the court to pass appropriate orders in your petition. And also taking into account the claim made by you that the undisputed amount should be released to you.
All right, my lord.
Yes, heard.
All right, my lord.
Counsel for the petitioner. This revision petition is filed by the petitioner putting a challenge to the order dated 28/1/2026, passed in CMA 14 of 2025, arising out of civil suit number 2 of 2025 before the Court of Civil Justice Senior Division, Kolasib District. Yeah. The short case projected before the court on behalf of the petitioner is that the petitioner had maintained an account under the which bank? HDFC.
My lord. HDFC. Respond number 2 branch.
HDFC bank, and the account was freezed by the bank authorities on the basis of an order dated 3/3/25, passed by the learned 11th Metropolitan Magistrate Saidapit in the state
If
of
I'm
Chennai.
allowed, my lord. Prior to the order, my bank account was freezed. Prior to the order of the magistrate, it was freezed before 14 February 2025. That magistrate order was 3rd March 2025.
All right, and you write that is it on the basis of a communication?
My lord, at page 79, my lord.
The account of the petitioner was freezed by the bank authorities on the basis of a communication.
It is Superintendent of Police, my lord, Chennai.
Dated 13th of February 2025,
Well.
2025, issued by the Cybercrime Wing Headquarters of the Tamil Nadu Police, requesting the bank authorities for freezing the account. Where is your account number here? Page number 79. Which is your account number?
My lord,
The said communication was issued on the basis of a complaint received by the Cybercrime Wing, Headquarters of the Tamil Nadu Police. Stop. Where is the order of the magistrate, Metropolitan Magistrate?
Page 82, your lordship.
82.
Yes.
So this was followed by the order dated 3rd of March 2025, issued by the Roman 11th, XITH 11th Metropolitan Magistrate Saidapet, Chennai. Passed in
CRL MP number 1967 of 2025.
in criminal MP number 1967 of 2025, whereby the account number of the petitioner in person, bearing account number, page number 82 to Sailuba, that serial number 1, maintained in the HDFC bank, containing an amount of rupees 27,90 for the amount of rupees 27,90,009.00 was directed to be freezed and submit a report to the court. Stop.
My lord, if I may, my lord, when it was directed to transfer the amount to the respond number 5, well, actually, that amount. When I page 82.
And because of the interim order, Lordship, I am not getting that amount, Lordship.
Okay. By the said order.
Contradictory order, actually.
By the said order, the said amount was directed to be transmitted to the account maintained by the private respondent number
5, Lordship.
who was the petitioner in the criminal mispetition.
No, I am the appellant in the writ appeal, Lordship. And in the writ petition, I am a private respondent, Lordship.
In this petition, you are respondent number 5.
Lordship.
Yes.
To the account of the respondent number 5, who has initially lodged a complaint before the cybercrime wing of the Tamil Nadu police. Stop. Being agreed with this order, the present writ petitioner filed WPC within bracket criminal 9 of 2025.
No, Lordship, I have not filed this, Lordship. The writ petitioner has filed. The petitioner has filed it, Lordship.
That's what we said. Petitioner has filed WPC 9, criminal 9 of 2025, praying for quashing of this order passed by the Metropolitan Magistrate at Saidapet, Chennai. Stop. An interim order was issued by the court staying the order of the criminal order passed in the criminal petition. You filed an appeal against the interim order.
Yes, Lordship.
Being agreed by the ex parte interim order, the appellant filed the respondent 5 as who was arrayed as private respondent number 5 in the writ petition, referred the appeal.
Writ appeal number 1 of 2026.
Writ appeal number 1 of 2026, which came to be allowed by judgment and order dated 2005-2026.
Paragraph 65 and 66 is the relevant portion.
Yes. The appellate court interfered with the interim order dated 13/1/2026, passed in writ appeal criminal number 9 of 2025, and the same was set aside. It was further directed that insofar as the writ petitioner seeks to assail the judicial order dated 3/3/25 passed by the 11th Metropolitan Magistrate Saidapet in Chennai in the criminal proceedings arising within the state of Tamil Nadu, the same is not constitutionally maintainable before the Gauhati High Court, and since the writ petition is pending on the file of the learned single judge, a formal order would be required to be recorded therein. Stop. In a sense, the division bench held that the writ petition criminal, WPC criminal of 9 of 2025 is not maintainable. In a sense, the division bench held that the writ petition being WPC criminal 9 of 2025 seeking quashment of the order of 3/3/25 passed by the 11 Metropolitan Magistrate Saidapet, Chennai is not maintainable. However, since the writ petition was pending, no orders were passed dismissing the writ petition. Rather, the matter was remanded to the single judge to pass appropriate orders. Stop. When did you file this CRP? The present criminal petition was filed on 12th of February 2026, challenging the order dated 28/1/2026 passed by the Civil Judge Senior Division Kolasip. Stop. According to the petitioner, the matter was heard by the court, and however, the concerned court declined to permit the petitioner to use the account to the extent of the amount available in the account to the credit of the writ petitioner, a credit of the present petitioner, which is not disputed. Stop. However, instead of permitting such usage of the account by the petitioner, the impugned order was passed, wherein it was held that the present application filed by the petitioner will have to await for the decision of the Honorable Gauhati High Court in WP Criminal 9 of 2025. When the matter was
But that is not on record, my lord. On that day, lordship, there was a hearing on that point, lordship. That is not on record, lordship.
We have recorded the submissions.
Lordship.
On 17/8/2026, when the matter came up before the court, after hearing the counsel for the parties, the court wanted to dispose of the matter. However, subsequently, from the case records available, it is seen that in deference to the order passed by the division bench, by the judgment and order dated so and so, no orders were passed by the concerned single bench closing or disposing of the writ petition criminal of number 9 of 2025 in terms of the judgment and order dated so and so passed in writ appeal number so and so. Stop. Consequently, the matter was listed today as during the submissions made by before the court, it was submitted on behalf of the private respondent number 5 that the writ petition criminal had stood dismissed by the division bench by its order dated 2005/2026, passed in writ appeal number so and so. Stop. Upon perusal of the pleadings available before the court, it is seen that the writ petition WPC criminal 9 of 2025 was not dismissed by the writ appellate court in writ appeal number so and so by the judgment and order dated so and so. Stop. Rather, it had interfered with the interim order and directed and relegated the matter back to the learned single judge for passing appropriate orders in view of its conclusion that a writ petition, the writ petition being WPC criminal 9 of 2025 is not maintainable insofar as its challenge made to the order dated so and so passed by the 11th Metropolitan Magistrate in the state of Chennai, in the state of Tamil Nadu. Stop. The Gauhati High Court, it was held that the Gauhati High Court does not have a territorial jurisdiction to interfere with such an order. Stop. Subsequently, it was pointed out by the from the registry, it is seen that the matter was indeed remanded back to the single bench, and the single bench by order dated
4/6/2026
4/6/2026 passed in WP criminal 9 of 2025 by referring to the judgment and order passed in writ appeal number 1 of 2026. Judgment and order dated 2/5/2026 had dismissed the writ petition as not being maintainable. Stop. In that view of the matter, this court is of the considered view that the issues raised in the present revision petition are essentially a challenge made to the order dated 28/1/2026 passed in CMA 14 of 2025 arising out of civil suit number 2 of 2025 passed in the Court of Civil Judge Senior Division, Gauhati District in the state of Aizawl. The grievance of the petitioner is that upon hearing the matter before the court, instead of passing appropriate orders permitting the petitioner to operate the account, at least to the extent of the funds which are not disputed by the opposite party defendants, the petitioner should be permitted to utilize these funds for his purposes. Stop. However, no such orders have been passed. The matter was kept pending on the ground that writ petition criminal 9 of 2025 was pending, and the present application filed by the petitioner before the Civil Judge Senior Division, Gauhati, will await for the decision of the Gauhati High Court in WPC Criminal 9 of 2025. Stop. Under such circumstances, in view of the discussions above, that writ petition Criminal 9 of 2025 came to be dismissed in view of the findings arrived at in writ appeal 1 of 2026 by the judgment and order dated so and so. There is no restraint for the Civil Judge Senior Division, Gauhati, Aizawl Judicial District to proceed for hearing of the matter CMA number 14 of 2025 arising out of civil suit number 2 of 2025 and thereafter pass appropriate orders. Stop. The learned Civil Judge Senior Division will take into consideration all the grievances raised by the parties before passing an appropriate order as directed. Stop. Let this exercise be completed within a period of 30 days from the date of receipt of a certified copy of this order. Criminal petition accordingly stands disposed in terms of the order passed today.
Lordship, our date may be fixed before the court so that we can appear, Lordship.
The civil court fixed as appropriate because the diary was there in every civil court.
Lordship, a date may be fixed so that we can appear, Lordship. Because for a long time it has been,
we have already ordered the matter to be disposed of within 30 days from the date of receipt of a certified copy. You file the certified copy before the court. Court will pass appropriate orders.
Correct.
Lordship.
I'm online, my lord.
Disposed. Yes.
Item number 7.
Lordship, I am appearing for Mizoram Public Service Commission.
Yes.
So, my lord, in this matter, I have to file my counter. My lord, we have prepared a counter now in the process of filing. So I'm seeking indulgent lordship for a short accommodation next week or whatever.
Yes.
With no objection, my lord. With no objection.
No objections.
However, lordship, if the interim order pass, may continue.
The counsel for the MPSC.
Yes.
Submits that their instructions are complete and they would like to file the affidavit within a period of 1 week from today.
Yes, lordship.
Right. Prayer made is not objected to by the counsel for the petitioner. You are appearing?
I am for private respondents except respondent 12 and 14, my lord. I may
12 and 14 except.
Yes. I may seek for 2 weeks time to file affidavit.
Mr. Lalraminga appears on behalf of the private respondents, appearing from respondents number 6.
8 to 23.
8.
8 to 23.
8 to 23 except
12 and 14.
respondents 12 and 14. He prays for 2 weeks' time to file the affidavit. Considering the above, let this matter be relisted on 22nd of September.
Fine, Lordship.
22nd of September, interim orders, if any, will continue till the next date of listing. The affidavits as permitted to be filed by the respondents be filed by before the next date of listing.
Much obliged.
Yes.
Item number 8.
Lordship, item number 8 to 16 are analogous case, and for the respondents, and I'm filing affidavit today, Lordship. So it may kindly be listed for admission hearing.
Counsel for the respondent submits that the affidavit will be filed today.
It's filing today, Lordship.
Be filed today. Prayer made is allowed. The petitioner is permitted to file the rejoinder affidavit if so advised. Matter be listed after 2 weeks.
Yes, but my lord, if a date may be fixed.
Relist this matter again on 17th.
Yes, my lord.
Lordship, if possible, not 17.
15th?
Maybe, yes, 15, Lordship.
15th.
And the interim order passed.
Interim order passed early will continue till the next date of listing.
Obliged.
Item number 9.
Item number 9. 9 is left over.
Same order.
Oh, okay. Same order.
16, 8 to 16, Lordship.
8 to 16. Yes. 8 to 16, same order.
Obliged, Lordship.
Item number 17.
Lordship, this RFA is filed against the order. Dated
This
39.
RFA is directed against the, where is the judgment and order?
Certified true copy is at Roman 1 to 3. It's a heresy publication. Your Lordship, in the last court order, my condemnation application was granted.
Condonation was granted. Against the order dated 3009-2021, along with the yearship certificate number 908 of 2021, issued by Senior Civil Judge number 4, Roman 4, Aizawl Judicial District, Aizawl. Admit, call for the records. List after 4 weeks, 3 weeks.
Yes, ma'am.
3 weeks.
Bless.
Item number 18.
Yes.
This IA has been filed seeking substitution, my lords, of one of the respondents. She had passed away on 9 June.
This IA is filed seeking substitution for the legal years of respondent number 2.
Yes. Respondent 2.
Any objections?
No, Your Lordship.
My lord, we are the leading counsel. We also have no objection.
All right.
Because he is the main, the only surviving before that. The one.
You're appearing for which department? You're
No, I'm-
representing which respondent? No objections
Your Lordship, he is appearing for the private respondents.
are raised by the state as well as by the council. The state council as well as by the council appearing for the private respondents. Accordingly, considering the submissions made and upon careful perusal of the application filed seeking impleadment, the application is allowed. The challenge made What is the challenge made
My
here?
lords, this is a regular first appeal against the judgment and decree passed by the senior civil judge. It's title
Declaring what?
declaring title, my lords.
Since the regular first appeal is directed against the judgment and decree dated so and so, passed in so and so, declaring the right title in interest in favor of the plaintiff.
Plaintiff.
Therefore, the right to sue insofar as the defendant number 2. You are defendant 2.
My lords, I am appellant. I am the appellants. We were defendants. The respondent was plaintiff number 2. The respondent we seeking substitution.
Okay. The respondent number 2 was plaintiff number 2.
Yes.
And since the right to sue survives, the legal representative of the said respondent number 2, namely Sri so and so, paragraph 4,
Yes.
residing at so and so, is permitted to be substituted in place of the deceased respondent number 2. Stop. I accordingly stands allowed. The applicant will file amended course title before the registry within 1 week.
My lords.
Para. In the RFA, you write, in view of the order passed in the IE, so-and-so has been substituted as the legal heir in place of defendant number 2, respondent number 2.
No
Petitioner will take steps to file amended course title before the registry as directed within 1 week. Matter will be listed thereafter.
Grateful.
Grateful, Lordship.
Item number 19.
My lord, the card regarding for respondent number 2 has not yet returned till date, my lord. So if the honorable court may direct the registry to track the consignment.
AD card for respondent 2, as per the office note dated 21/8/26, is not received. The registry will make necessary endorsements upon verification of the postal track receipts.
And my lord, if I may,
Yes, Lordship, I'm here for the respondent number 3. So in this matter, let the paper book be prepared.
Since the records are received,
Yes,
trial court
TCR.
records are received.
No.
Since the TCRs are received, the registry will prepare the paper book at the cost of the appellant. And thereafter serve copies on the respective counsel.
my lord,
Released after 4 weeks.
Obliged.
obliged.
Item number 20.
May it please your lordship, as the learned counsel for the respondent is not present today, may I seek your lordship's indulgence that the matter may be kindly be listed on another date?
You are a counsel.
Yes, for the applicant.
You're not properly attired. You have to appear before the court.
Sorry, my lord. I'm so sorry, my lord.
All right.
I'm sorry, my lord.
On the request of the counsel for the appearing for the
Applicant, my lord.
applicant.
Yes, my lord.
Uh,
And there are two IA number 135.
We'll defer it to be listed next week.
Okay.
The matter stands deferred to be listed next week.
Once again, sorry, my lord.
Relist next week.
Item number 21.
Yes, may it please your lordship, I'm here for the appellant, and in this IA, we are seeking a continuation of 106 days delay in filing the connected RFA against the judgment and order dated 4/2/2026.
This is the first time it has come?
First time, lordship.
Okay, heard counsel for parties is an application under Section 5 of the Limitation Act 1963, seeking a condonation for a delay of 106 days in preferring the accompanying regular first appeal against the judgment and order dated 4/2/2026 and the decree drawn thereupon. Stop. You should notice returnable 4 weeks. Steps on the respondent by speed post within 1 week from today. Release this matter after the returnable date.
Indulgence in making mention of one unlisted item.
Unlisted?
Yes, my lord.
Oh, today?
For Thursday, 27.
Thursday, what is the matter about?
It's a bail application.
Bail application. You mentioned it before the second court.
I was mentioning.
All right,
yes,
permitted. Permitted.
Much obliged.
Eh?